Welcome to the Probate Realtor Show, your one source for selling and buying real estate through trust and probate. Hear directly from the best attorneys and trusted advisors on how executors and administrators navigate the probate process in and out of court. Being a personal representative or successor trustee can be a daunting task, and often beneficiaries don't have a clear plan. Let us help you make the right decision for your clients, your family, and your legacy. And now, here's your host, the probate realtor himself, Matias Baker Masucci.
Welcome, everybody, to another very exciting episode of the Probate Realtor Show. Today, we have the privilege of talking to the high energetic and incredibly friendly Patricia De Fonte. Patricia, welcome to the show.
Thank you so much for pronouncing my last name correctly. I am thrilled to be here.
Very good. Yes, as an Italian, I better pronounce the last name correctly.
Yes.
Patricia is an estate planning attorney with De Fonte Law, and it's her, as you can see, her tagline is estate planning with a heart. And today, we are going to talk about vesting. This is so important that please pay attention, because when you buy real estate, if you don't understand vesting, you can get yourself in big trouble. So, Patricia, let's start with this. What is vesting?
Okay, so when you buy a piece of property, a deed is created. And it says, this property is being transferred from the seller to the buyer, right? But that's not all it says. And it says, and the way that the buyer is going to own it is like this. And then it lists how the buyer is going to own it. And so that is really simply put vesting. That's how you own the piece of property that you just purchased.
Very good. Very good explanation. And now let's get into a little bit deeper. What are the different type of vestings available to a person when they are taking title to real estate?
Sure. So if you're just one person, you're going to be the only owner. You purchase it as a single person, unmarried, because you always want to state your marital status.
Right.
You can take ownership as a married person, as your sole and separate property.
Right.
So that's what you can do if you're a single person. And it's really important to state whether or not you're married. And then if you are in a couple, a married couple, then you can do a tenancy in common. You can do a joint tenancy, and you can do community property. All three of those have very different results when one owner dies. All three of those have very different results when each owner dies as to reassessment under Prop 13, which all Californians are obsessed with, and very different results as to who would inherit the property if you don't have a trust in place to say who's going to get it. Matias, I forgot to say something.
Yes.
Okay, so I'm an attorney, but what I'm not doing is providing any legal advice. So everything you hear today, this is like a bird's eye overview of vesting, but the law is the application of facts to whatever the statutes are and then whatever judges have said. And so I don't know what's right for you. There is no one answer as to what is right for you. So it's really important to talk to a lawyer to determine how you should vest. Please don't do this at home alone.
I agree with that. And we have a very good disclaimer. Thank you for saying that. But our show has a very wonderful disclaimer about the fact that this is for entertainment purposes only. So thank you for reminding our audience. Now, what you mentioned brings us, it's interesting because you said when different things happen when people pass away. Very, very important, because this ties us in with the estate planning portion, which is what the show talks about and touches upon a lot. So what are the differences? What difference does it make if me and my wife are buying an investment property with the money that I inherited from my dad, and we are taking it as tenants in common?
Okay, that's a big hypothetical.
I know,
okay.
I know.
So let's back up a little bit. When you own property as tenants in common, generally the reason that you're going to want to do that is because you don't have a 50-50 ownership interest. One person is putting in a certain amount of money, so they're going to own, say, 5%, and the other person is going to own 95%.
Right.
Now, what happens when one person, and you can have 20 people in this TIC, right? 2 people, all the people, however you want to set it up, it's up to you. When one person dies, then their portion that they own will be generally speaking, reassessed under Prop 13. And if they haven't put it into a revocable trust, it will go through a process called probate. And probate means that a court is overseeing the transfer of your assets to whoever is next in line. Now, with a tenancy in common, the person who's next in line is not the other owner. It won't be the other owners unless you take some affirmative steps to say, I am leaving my equity interest in this property to the other owners. So if you don't have a plan and you have a baby and you're not married, then now all the other owners of the TIC own property with your baby. This is not fun for the baby or for all of the other owners, because then the court has to get involved and determine what's in the best interest for the baby. And the judge might say, the best thing for the baby is to sell this property. So it's pretty dangerous when you are owning real estate with other people and you have a tenancy in common. You absolutely have to work with a lawyer to develop a tenancy in common agreement, which requires every single member of the TIC to have a revocable trust to avoid probate, and that sets the rules as to what is supposed to happen to the different ownership interests as the owners pass away. And we see this a lot. TICs are really common in Northern California, but they're also really common for vacation properties, right? A bunch of friends want to buy a cabin up in, wherever it is they like to ski, or a lodge on the lake, and then somebody loses their job or somebody gets married. So what's happening, right? What are the rules of this game? How are we making sure that everything is being paid for as the years go by? What happens when people die? What happens when people get married? You've got to set some rules around this.
Exactly. Okay, let me take it back for one step, because I want to make sure that the audience understands something that Patricia said, which is very important, is the fact that the property gets reassessed. So if you don't know what that means, it means that your property taxes, because we live in California, most likely will go up because they're based on the property value of when it was purchased, or whenever there was another reassessable event. So if you purchased the property for $100,000 20 years ago, and now it's worth $1 million, and that situation happens where it's a reassessment event is triggered, then the taxes will be reassessed on the new property value, which is $1 million, which is a huge change. It's a huge difference. And it makes a big difference for people who inherit properties, et cetera, et cetera. So without getting into too much details on that, because we are talking about vesting, I just want to make sure the audience understand that part. Now, let's take it a little bit of a step back. We talked about joint tenancy, and we also talk about community property, things that are, there's slight difference between states, but we are talking about California. So let's explain. Could you explain to our audience what a joint tenancy is?
Sure. In a joint tenancy, and again, it doesn't have to be just two people, it can be lots of people, but you all have to vest together. Everybody has to be on the deed at the same time,
right,
in order for there to be this right of survivorship. So what that means is, let's say 3 people buy a property together. One of them dies. Because of the right of survivorship, the other 2 inherit that other third. They split it between themselves. So now each of them own a half. But that 1/3 of the person who died, reassessed, but no probate. So we've solved one problem, but we still have the problem of reassessment. Right. And that's where you want this other co-owner to have a lot of life insurance and leave you some.
There you go.
Right? Because it's not just about what you're doing with the real estate now, it's what you're doing with the real estate in the future. And anyone can have a joint tenancy. You can have a joint tenancy with perfect strangers, with friends, with family members, and with a spouse.
Right.
Right?
Now, in the case of one spouse passing and the other one inheriting, that does not trigger a reassessment event, right?
For a spouse, no. But here's the problem. When spouses own real estate as a joint tenancy, what the statutes tell us, the federal statutes tell us, is that one spouse dies. If the surviving spouse decides, I can't live here anymore, I don't want to be in this house anymore, and they sell, there's capital gains exposure for the 50% of the home that's owned by the surviving spouse.
Got it. Yes.
So not a great outcome. But if they decide, I'm going to stay in the house, how could I ever leave this home? All my memories are in this home. and they pass away. So when the children inherit, the surviving spouse, they're 50%, that's clear, no capital gain. But we have to look at the date that the first spouse died up to the date the second spouse died, and there might be capital gains exposure there. And so for married couples, they really have to look very carefully. Should this be a joint tenancy or should this be community property? And now, should I explain community property?
Yes, please.
Okay. So community property is only available for married couples in California. Domestic partners who are registered with the state of California. So not your county registration for health benefits, but registered with the state of California. So what happens with community property is one spouse dies, the other inherits, no taxable event. If that person, the surviving spouse, decides to sell, no capital gains. If they decide to keep it and they live an extra 40 years and there's all this appreciation, they die, no capital gains. But here's the problem. Married people keep getting advice to, well, you're married, just do community property. But we always have to look at where is the money coming from. And that's how we help clients do the analysis of joint tenancy or community property. Because if you are a newlywed and you are throwing in a lot of your premarital money to purchase this family house, how are you going to feel if 3 years later you took title as community property? Because under the family law statutes, now this is 50-50. And so your spouse walks away with half of what you see as yours. And so you have to be very, very careful. There was a woman who called every lawyer in town a couple of years ago. Her mother had given her $2 million to buy a house. They took title as community property because they got bad advice from a non-attorney. And he had her over a barrel. And he would not negotiate with her unless she gave him all of her RSUs. So I don't know what happened there because I didn't work with her, but it was a mess, and this stuff comes up all the time. So when you're trying to figure out, should this be a tenancy in common? Should it be community property? Should it be a joint tenancy? Should it just, even though I'm married, just be mine? You really have to think about, where is the money coming from? And also, how are we paying down this mortgage? How is this mortgage going to be paid? And all of those things will feed into making a determination as to how to vest. The problem is that nobody asks you how you want to vest or take title. They'll also say, how do you want to vest? How do you want to take title? How do you want to own this? About 3 days before escrow is going to close, somebody at the title company will hand you a piece of paper with a list. One of the things on that list is, as trustees, you take title. Married people, listen to me, you're going to take title to property as trustees. The presumption is that it's community property. So once again, where did the money come from? An inheritance, a gift, your separate property? You are not going to be happy if you get divorced later, because it's going to be a huge argument as to what does it actually mean? How do we really own this? So at my firm, we have clients take title. We have them vest exactly how they want it to be on the face of the deed. And then we do the transfer into the revocable trust to avoid probate. Two-step process. And sometimes we'll get a nice title agent who will do both deeds, but most of the time they just won't. And so we'll do it.
Thank you so much for explaining this. This is so important because it just shows the intricacies of how, estate planning ties in with the vesting. There is so much truth to that. When I do court confirmed sales, we have to announce the vesting prior to even opening escrow because the court has to know the vesting. So when you're doing when there's limited authority in a probate sale, we get involved with asking people, how would you like to take the property even before it goes to court? Because when the court signs that order, it has to say, as a buyer, it has to say exactly how you're taking property because it's got to match. They will use that court order. The title company will use that court order to register the deed. So that is very important. Thank you very much.
In 24 hours, I did an estate plan for a client. He was court ordered to take title to inherited property as a trustee of a trust that did not exist. And so we had to create that trust overnight in order to comply with the court order. How any of this happened, this fantasy, I don't know. I don't remember, but it was a mess.
Right. Yeah,
It was a
so
mess.
it's very important to consult a professional when it comes to vesting and when it comes to this type of things. Now, let's talk about the estate plan portion of and how the vesting plays a role. You briefly talked about the trust, which I think it's important. But what about, Patricia, what about people that come to you that own a lot of real estate already? They have done zero planning, so they already have all sorts of manners of taking title out there. How do you help them?
Sure. One of the things that I see a lot is we own the house, but we're not on title because of the lender, or we added mom because she was going to help with the loan. We see all kinds of strange things on deeds.
Mhm.
And so a big thing we do is we're good issue spotters. And so we're going to look at every single deed. We're going to ask questions about where did the money come from to purchase this? What is the intent with this property? And do you understand what starts happening when people die? Is a reassessment going to be triggered? Does the other owner have an estate plan, or do you own real estate with someone who, when they die, it's going to go through probate and you're going to wind up owning real estate with your boyfriend's mom? Like,
Right.
who knows, right? And so it's a really careful analysis with each one. And then we talk about, well, okay, is this your primary residence? Is this an income producing residence? Let's talk about insurance. Let's talk about LLCs. Let's talk about what is the best play for you moving forward with one of the biggest assets in your life, your home. Another big thing that comes up all the time is really typical family, and they have the primary residence and a bunch of adult children. And initially, everybody wants to just leave everything equally to all the kids, right? Because that seems fair. A lot of estate planning lawyers will just do what the client says. I can't, because what I want to do is get all the information about all the different kids, who lives around, who's the one who likes to host Thanksgiving, who are these people? And now let's talk about what are the goals for the family. Because if you divide this piece of property among 5 kids, no one's going to keep the house, right? There's a fantasy that, oh, well, the children will come together and the one who really wants to live there can just buy the rest of them out. What are the interest rates going to be when this happens?
Mm-hmm.
I don't know. Also, instead of giving each child a nice, clean, tax-free inheritance, instead what you're giving them is transfer tax and income tax and gift tax problems. So it's really important to guide a client through whether they have a lot of real estate or just, sometimes more importantly, just that primary residence, to make sure that the family can keep having Thanksgiving in a house that's been in the family for generations. Another big hiccup has been Prop 19. Now, I did not, but a lot of Californians got tricked into voting yes on Prop 19. And on the first page of Prop 19, it seems nice. We're going to help people over 55 and fire victims be able to move anywhere in California, and they can take their property tax basis with them. So that's wonderful. Unfortunately, on the back, the Realtors Association also added that all property that is inherited, except for a pretty small carve out for a primary residence, is going to be reassessed. So now if you're leaving your primary residence to your son, who's going to live in it, and your income producing property or a vacation home to your daughter gets the never ending gift of increased property taxes. And it's usually tens of thousands of dollars every year.
Right.
So how do we balance that in the estate plan to make sure that we're really doing apples and not apples and oranges? So dealing with the real estate holdings of a client, they start to get bored because it's really slow and methodical, and we're asking the same questions for each piece of real estate. But until we get all of the information, and then we know who all of the players are, who are all of these people, then we can kind of start matching assets to people. And because family harmony is at the core of what we do. And it doesn't help anyone if the house that everybody goes to for Christmas has to be sold because the lawyer just did what an uninformed client asked them to do. Drives me nuts.
Yeah, that makes sense. Thank you for explaining that. Let's briefly touch upon the common mistakes. I think we talked about it, but what are some of the most common mistakes you've seen in your practice when it comes to vesting?
Sure. I see, oh, please don't go to the recorder's office and do your own deed. I see all kinds of crazy things. I have seen, from the buyer to Lisa and Jeff. Doesn't say if they're married, doesn't say how they're supposed to own it, There's no vesting information whatsoever. I can't believe the recorder let it get past their nose, but they did, right? This deed was accepted. So that's a huge problem. Adding third parties to the deed. Oh, I'll add my kids to my deed, and then when I die, they'll just inherit it. It's not the way it works. I had clients who, so her mom had 5 children. 4 of them were great. The 5th one, a ton of DUIs, no job, still living at home with mom. But she put all of the kids on title to the house, thinking, when I die, this will be great. It was not great at all, because once you own real estate with someone else, if they take a bunch of drugs and create a ton of liability and they don't have a job, what do they own? They own part of your house.
Mm-hmm.
Don't let other people own part of your house, okay? Please don't listen to people on TikTok about how you should add your family members to your deed. Never add a minor to your deed, because you will not be able to sell or refinance or really do anything, because a judge will have to get involved and decide what's in the best interest of that child. You don't have free reign anymore, and you can't just take the child off. You're just not allowed to do it. So don't do it, okay? Don't do these things. Another thing I see all the time is, and I wish I didn't see it as often, is my friend and I bought a piece of property. It's in my name. I'm married, but my friend is paying the property tax, and it's a rental, and we split the rents, on and on and on and on. Okay, but if we look at the deed, it says that you own it, and your friend's name is nowhere here. Also, you bought this, you're married, and you bought this with your married money. This is a community asset. So you actually, your wife, even though she's not on the deed, she owns it too, right? And your friend, when you die, is going to be nothing but furious. But you know what he's going to get? Nothing. Because everything related to real estate, any agreement about real estate has to be in writing. You can't have oral agreements about real estate. Then this is old law from England. Old law that we learned like in the first 3 weeks of law school. So anything that you're doing with real estate, whether you have a tenancy in common, whatever it is that you're doing, it all has to be reduced to a writing written by a lawyer, a qualified lawyer, okay? Somebody who understands all of the intricacies, because it's real estate law, contract law, and estate planning. Those 3 areas need to come together to make sure that you're protected 360.
If my audience is interested in finding out about the statute of fraud and why real estate contracts have to be in writing, it has to do with a rooster. Please go and look it up. It's a funny story.
I can't wait.
Okay, so this is wonderful. Thank you so much. I want to talk about your practice a little bit, because we've had a few interactions, and I was really I really enjoyed listening about the way De Fonte law handles clients and why the symbols that you have. I know that you have an apple tree as a logo and all those things. Please tell us, because I think it will be very beneficial for the audience to know.
I love it, and I will, but I want to leave everybody with one really important thing.
Absolutely.
The lenders are bullies, and the lenders will tell you your spouse cannot be on title or has to be on title.
Mm-hmm.
And this can be incredibly problematic. You owned a piece of real estate before you got married. You want to refinance it, and they're trying to force you to put your spouse's name on that. You don't want that, because you want to leave that property to your sister, your kids, whatever. Bring a lawyer into the equation. Do not let a lender bully you and tell you how you own your property. And a big thing in refinancing is they'll force you, if you have it in a trust, to pull it out, and then they say they're going to put it back in. Watch them carefully. I owned real estate as community property. The lender forced it out, and they changed it to joint tenancy. And I tried to change the deeds and explain it to them. They wouldn't believe me. My mortgage broker, in writing, he and his assistant, and also the title company, in writing, told me it didn't matter because it was in the trust. A revocable trust does not change the vesting. Transfer to a revocable trust avoids probate. Does not change the way you own it. So who got to pay my family law attorney to fix all this? My mortgage broker, who will never get another referral from me as long as I shall live. What a hack. But I got a great rate, 1.99. So my firm. So I do have the apple pie tree of life, which was
There
made
you
for me
go.
by a very good friend of mine who's a 5th generation jewelry maker and blacksmith. And the reason she made it for me is because I plant a lot of trees and I love apple pie. And it's a trope for an estate planning lawyer to have a tree as a logo, strong foundation for your family tree. But this has really become kind of the heart of the firm. And the reason that it's the apple pie tree of life is when I was very young, I asked my dad what happens to us when we die. And my dad's fine. I was just on vacation with him. He said, don't worry, we just walk past the sun, past the moon until we get to the apple pie tree. So that's perfect for me. I wanted to be Lieutenant Uhuru, a scientist in space in a groovy outfit. Yes. And my favorite food then, always, apple pie. And so that's why it's that. And this tagline, estate planning with heart, we are not a group of tax nerds at my firm. I have a master's degree in estate planning, probate, and trust admin. One of my associates has a master's in tax. That's not where we live. Where we live is family harmony. We live in how do we create a plan that protects your heirs, your spouse, your partner, your kids, the other people you're worried about, protects them from predators and creeps, that sets them up for financial success as they start using their money, that promotes family harmony. How do we use the money in the trust to make sure that there's family togetherness, right? How do we honor everybody that we want to honor? And then how do we evade all the, people that we don't like so much in our lives? And so that's why we spend so much time with our clients. We spend 4 hours per client over 3 meetings, not all in one day, because that would be too much togetherness in one day. We want to make sure that we know our clients. And so that first meeting, we tell the clients, you don't have to remember anything. Lawyers learning meeting. We need to know you and we need to know your stuff and how you feel about it. And we want to make sure you have a great CPA, great financial advisor, terrific insurance. Everybody please get umbrella insurance. The next meeting, we want to make sure the clients understand the documents, because until you understand all the rights and authority and what you're really asking people to do, you're not sure that you've named the right people. It's not most, but about 50% of clients change the names or the order once they see what the actual work is. Mm-hmm. We offer online and in-person notarization, and then the final meeting, because having a revocable trust is like having a safe. But if you just pile your stuff on top of the safe, it doesn't work. So we have to teach you, how do I manage my assets over time? What do I do? What do I do with my bank account? What do I do with my RSUs? What do I do with my cat? What do I do, right? And so we have a 30-minute meeting. If you have a financial advisor, we want them to come. And then we'll send you the ugliest green envelope you have ever seen. It is borderline offensive. I did ask at the stationery store for the ugliest one, and they really came through. And the idea is you cannot throw it away until you are done making your title changes and your beneficiary changes. And so all of our clients get to celebrate by ripping that up and throwing it into the air and then cleaning that up and throwing it away when they're done. And the idea is it can't get lost in a stack of mail. If it slides under the couch, it's practically going to glow in the dark, because it's really, really important to get that work done. And we'll provide support. We'll write to all of your advisors, provide them with some discrete documents so that they can do some of the heavy lifting of creating forms for you so that you can just sign to make sure that things are getting done. So it's a pretty robust process. I'd say clients are spending 10 to 15 hours on the entire process total, 4 hours with us, and then additional time doing their insurance review, interviewing financial advisors or talking to their advisor, working on the funding, talking to their guardians, talking to the successors and agents that they want to name. It's charming and it's affirming. And I've had married couples tell me, we've been married for 20 years, but I really feel married now, because it is a very adult journey. And the number one trigger for estate planning is turning 18. Okay, turning 18, getting engaged, thinking about buying a house, thinking about having a baby. Don't wait until you're actually doing these things. Jump on board early. Estate planning is for everybody.
Thank you. This is so wonderful. It's been such a pleasure to have you on this show. Thank you for sharing all these very valuable information with our audience. Before I let you go, one more thing. How can, if anybody wants to get a hold of you, what is the best way to reach you?
Sure. Always the best way to reach anybody in my firm is through our website. We have, there's a form that you can fill in, and that goes to numerous team members. So we can write back to you right away and then schedule you for a 20-minute discovery call.
Perfect. Let's plug it. What's the address for your website?
defontelaw.com or estateplanningwithheart.com.
Beautiful. Thank you so much, Patricia. It's been a pleasure to have you on the show. And do you have any parting words for our audience?
Please, please, please take estate planning seriously. We've all seen the GoFundMes. We've all heard the horror stories, and we all think nothing bad is going to happen to us. Part of the reason I do this work is I saw 2 terrible things, and it made me change my practice area. And so now I do this so that I can help people avoid the worst case scenario. California has a plan for you. It's terrible. You got to opt out, and please do it with a qualified lawyer.
Thank you so much. And maybe we'll have you back and we'll hear those horror stories as well so the audience can learn.
Sure.
Thank you, everybody, for joining us. Have a great rest of your day. Bye.
Thank you for listening to the Probate Realtor Show. Find more episodes and interact with us at probaterealtor.la. That's probaterealtor.la. Listen, ask questions, and get results. Don't forget to like and subscribe. The Probate Realtor Matias Baker Masucci is a licensed real estate broker in California, DRE number 020547763. Any legal information provided is for informational purposes only and not for the purpose of providing legal advice. Contact an attorney to obtain advice with respect to any particular legal issue or problem. We make no guarantees as to the accuracy of any information. Thank you again for listening, and we'll see you in the next episode.